Jane at 1-800-510-JANE.
Should juries be told that if the accused has a criminal record? That's what we're asking tonight. Our guests are Wendy Carroll and her lawyer, Tim Danson. Joining us now is Karen McArthur, a criminal defense lawyer. Nice to see you, Karen.
Nice to see you, Jane.
Now, give me the other side. Why is it not a good idea for the juries to be told that someone has a criminal past?
In certain circumstances, they are told when credibility is a key issue.
Right.
You bring an application to oppose the jury hearing about the criminal record if the defendant is going to testify, and sometimes the judge rules in favor of the defendant. The reasons that you put forward for not letting the jury hear the entirety of the criminal record are that they will misperceive it and perceive that the defendant is a bad character or has a propensity to commit the offenses. And you're going to put the person's history on trial, which will necessarily prolong the trial, and it will cost more money. That's the simple answer to why I don't think the entirety of the criminal record should always go before a jury.
Right. But in a case like this, where where you're looking at attempted murder, isn't it important for the jurors to know that they've been twice convicted of murder, both of them?
Well, there's a legal test that Crown prosecutors and Ms. Montague, who prosecuted Wendy Carroll's case, can apply for. It's a similar fact. And if the prior murders committed by Mr. Kehoe or by Mr. Schwartz were similar to what they attempted to do to Wendy, if on the balance of probabilities the Crown was able to satisfy the judge of that, then the jury would get to hear about it. Whether or not the defendants testified, they would get to hear about that in the prosecutor's case. So there's already that tool or weapon available for the Crown Counsel, for prosecutors.
So would you guess that he would have turned down the request because Kehoe smothered his two children, so it wasn't similar enough to what happened to Wendy? Is that the argument?
The test is it has to be strikingly similar, but the only legal threshold that the prosecutor has to go over is balance of probabilities. So pretty much anything goes if it's similar. Now, what he did was dissimilar.
Right.
As I understand it, was the killing of his two infant daughters, and what Mr. Schwartz did was also dissimilar. It was the killing of an ex-girlfriend and ex-boyfriend, as I understand.
So I believe he stabbed them, didn't he? Weren't they stabbed to death?
His Schwartz's girlfriend? Yeah. No, he actually took a shotgun, and as I understand the facts, and pointed it at the boyfriend's face and pulled the trigger. Right. And then shot her and used a knife, and it was fairly brutal murder.
Right.
Yeah. The other thing with both Mr. Kehoe and Mr. Schwartz, as I understand it, is that they had committed the offenses in the early 70s, were released on parole. I think Mr. Kehoe shortly thereafter. I think he might have been convicted of something akin to manslaughter. It was non-capital murder, because Tim and I were discussing before we went on the show, he was in the pen, if you will, for I think 3 to 4 years and then out on day parole. So it suggests it was manslaughter. But in any event, both of them were on full parole by the mid-80s. And this offense, unfortunately for Ms. Carroll, occurred 11 years later. So really they were living out in the community, safe and soundly for the community and for them, for 11 years. As far as we know, yes, as far as we know. And the parole violations that they were committed, as I understand, were not advising the parole authorities of their appropriate addresses. And then what occurred to Ms. Carroll, which is extraordinarily unfortunate, and I'm deeply sorry.
So, but you think this is the appropriate action, that that the jury shouldn't have been told, and this was the way that the case should have been carried out?
Courtrooms are about balancing, the old scales of justice, and it's a difficult balancing act. The law is there for a reason. It's there to ensure that people get fair trials and that innocent people aren't wrongly convicted because of their past. So it's a tough balancing act, but that's what courtrooms are all about. Okay,
let's talk to Trevor, who's calling from Edmonton. Hi, Trevor.
Hi, how are you?
Good, thanks. What do you think?
I think, should the question or should the jury know of prior convictions? My answer is no. I mean, everything prior is irrelevant, so that's my standing.
You think it's totally irrelevant?
Well, I mean, there's exceptions to everything, but...
Well, how about if they put their character in issue?
Sure.
Do you think it's irrelevant then? I mean, if Mr. Kehoe said, for example, on the witness stand, I mean, why would you convict me of attempting to murder Wendy Carroll? I'm not the kind of person who would do that kind of thing. Well, I mean, in that situation, don't you think that opens it up for the Crown to come back and say, what do you mean you're not the kind of person who would commit murder? You've killed 2 of your children. Wouldn't you consider that to be a fair area of cross-examination?
Well, sure. We can say whatever we want. I don't know.
Thanks very much for calling, Trevor. Let's talk to Laura, who's calling from Kingston. Hi, Laura.
Hi there. How are you?
Good, thanks. What do you think?
Well, having been a victim of crime myself,
I think I really have to side a lot with Wendy. It seems to me that anyone who's got a violent or recidivistic violent criminal past, they should be really looked at, and I think that their past should be recognized. And the lawyer who you have speaking this evening is, I think, not really looking at things quite balanced, because I think that, you have these people who have violent criminal pasts and, they are not looked at all. But somebody who's a victim has no right to really speak at all. I was a year and a half stalked by a recidivistic criminal with a very, very violent past, and I didn't even get to go to court to speak my piece. Right. So,
and Laura, Wendy, you may want to speak to that, because I know that it was hard for you, because in essence, all you are is a witness at a trial like this. You're the witness at the trial, at someone else's trial.
Very limited in what you can say, and you feel like there's so much information you want to try to get across that you don't have any opportunity to. So I'm surprised she wasn't even allowed in court. But it doesn't surprise me. Almost every woman I speak to has her own horror story. And I look to you and I say, I hope something doesn't have to happen to you before your views change.
Wendy, we don't have to personalize this situation. My job is here. My professional job is that of an advocate. I advance one side of the scales of justice. There are very vigorous opponents on the other side of the scales of justice in the courtroom. We hope that through a vigorous fight, we get to the right result and we don't get wrongful convictions. The caller who's just indicated that she wasn't able to participate as a victim perhaps wasn't apprised of the rights that she has available to her at the sentencing stage of a trial, for example. As I'm sure you know, Wendy, you can put in victim impact statements, and so you are a vital part of the system above and beyond merely being a witness.
You want to investigate the possibilities of such. Because nobody approached me to tell me what my rights were, what I could or couldn't do at all. Nobody. And
I think we hear this over and over again from people who are victims, that they're really shocked when they go into the criminal process, because they think it's about them. They're the ones that are victims of this. But when you get to the trial process, it really isn't. It's about the accused. That's the trial that's happening.
Unfortunately, trials and courts in Canada today are places where things happen fast and furiously, both for the complainants and the victims and for the defendants. I mean, equally on the other side of the coin, defendants feel that they're pushed through the system. Day in and day out, we see that defendants go to court without lawyers now because of funding cutbacks, and you'll go to overcrowded courtrooms. You've got 200, 300 defendants in a courtroom. People are not getting attention on either side, and what probably is happening is that guilty people are being exonerated, perhaps wrongfully, and innocent people are being wrongfully convicted. It happens on both sides.
Should juries be told about prior convictions? We'll come back with more of your calls and your email. This is Jane Hawtin Live.